Good evening. Before I begin, I want to thank everyone for being here tonight, especially my mom, who has unwaveringly supported me in law school and beyond, Professor Christensen for his invaluable patience and guidance throughout my writing process, Heather Veronini for her thoughtful direction and critiquing my note, Professor Babcock and the Law Review staff, past and present, for their hard work in editing my note and believing in me enough to give me this opportunity. The Constitution is credited as conferring to citizens a general right to be let alone. The court has gradually expanded on this right by acknowledging that there are zones of individual privacy that should be free from government interference, and more specifically, that the choices central to personal dignity and autonomy are central to the liberty protected by the Constitution. The Supreme Court has further acknowledged that this right to be let alone extends to all private consensual sexual conduct. My note is titled Constitutional Protection for the Public Employee in Matters Pertaining to Sex, and it evaluates the case of Perez v. City of Roseville, a case so interesting that the Ninth Circuit decided it twice. The issue here is whether and when the government may use its position as an employer to infringe on the personal autonomy rights of the individual employee. Put another way, whether and to what extent a person must sacrifice aspects of her constitutional rights, in this case to privacy and intimate association, when she accepts a position with a government employer. Shortly after her appointment to the Roseville Police Department, Janelle Perez began a romantic relationship with a fellow officer, Shad Begley. Both officers were estranged from, though still legally married to other people. About 6 months into the relationship, Begley's estranged wife filed a citizen complaint alleging that the officers were engaging in sexual conduct while on duty. An internal affairs investigation found this allegation to be false, but did uncover the truth of the off-duty relationship. The investigation also revealed that the officers were using their cell phones excessively while on duty. However, while this was a concern, it was found not to be one that warranted termination. Now, despite finding no merit to the allegation of on-duty sexual conduct, the department issued both officers written reprimands, charging them with unsatisfactory work performance and conduct unbecoming. The commanding officers later made comments that they morally objected to Perez's extramarital sexual conduct. Perez was thereafter terminated with no further explanation. A week after her termination, Perez received a revised written reprimand that reversed the findings of unsatisfactory work performance and conduct unbecoming, and introduced new charges of use of personal communication devices. Officer Perez sued, alleging that the department violated her constitutional rights to privacy and intimate association by basing her termination on its moral disapproval of her off-duty sexual conduct. The district court granted summary judgment for the defendants, and Perez appealed to the Ninth Circuit. Now, the Ninth Circuit originally decided this matter in February 2018 in an opinion authored by Judge Reinhardt. In that opinion, the court held that the precedent set by the Ninth Circuit's 1983 decision in Thorne v. City of El Segundo, as well as the Supreme Court's decision in Lawrence v. Texas, governed the department's conduct and protected the employee's privacy rights. In Thorne, the court held that this type of intrusion should be evaluated under heightened scrutiny, specifically that unless there is evidence that private off-duty activities negatively affect an employee's job performance or otherwise violate a constitutionally valid departmental policy, the government employer may not consider such information in its decision to reject or terminate an employment relationship. This analysis was strengthened by the seminal Lawrence v. Texas, in which the Supreme Court invalidated a Texas law prescribing homosexual conduct, and according to some interpretations, prohibited the state from using majoritarian bias to mandate its own moral code. The court thus found that while the investigation was lawful because of the allegation of on-duty conduct, Perez's termination, in light of the falsity of the allegations, was not lawful. The court concluded that there was enough evidence to suggest that the department based its decision on the commanding officer's personal biases and remanded the case to the district court. Now, after the court issued its original opinion, a member of the court petitioned for a rehearing en banc, and before he was able to issue a final mandate, Judge Reinhardt passed away. The court thereafter withdrew its original decision and issued a new decision which draws contrary conclusions, which incidentally was shortly after I received my publication decision. Now, the court's 2019 currently binding decision relied on the revised phone usage reprimand to conclude that Perez's extramarital relationship did in fact affect her on-the-job performance. The court determined that Perez was not terminated because of department disapproval of her affair, but because of excessive cell phone use in connection with that affair. Further, the court interpreted the binding precedent in Thorne as explicitly rejecting a per se rule that a police department can never use its employees' sexual relations in personnel decisions. To this end, the court cited its later decisions, one which upheld the termination of officers who had engaged in sexual conduct with sex workers while on duty, and another that upheld an officer's termination for off-duty activity that amounted to criminal sexual misconduct. Considering these cases along with Thorne, the court determined that the precedents are not so clear that every reasonable officer would understand the constitutional impermissibility of considering Perez's extramarital affair as part of their termination decision when such affair led to inappropriate personal cell phone use while on the job. As such, the court affirmed the district court's grant of summary judgment, holding that the officers were entitled to qualified immunity. By redeciding this issue, the Ninth Circuit missed an opportunity to clarify the appropriate relationship between the interests of the government employer and the personal autonomy rights of its employee. The original Perez decision furthers the awareness of individual autonomy rights by acknowledging that the state may not stigmatize private sexual conduct simply because the majority has traditionally viewed a particular practice, such as extramarital sex, as immoral. This principle applies with equal force to the government employer as it does when the government is acting as a sovereign. After all, a citizen who works for the government is nonetheless a citizen. This means that government employers must not be permitted to take adverse action against an employee based on the employer's own conception of morality. If a government employer must interfere in the personal off-duty conduct of the employer must be required to show a significant interest in doing so. That is, the government's interest must be related to the employment relationship itself. The Ninth Circuit's conclusions in its first opinion appropriately apply controlling precedent and appropriately interpret the facts of the case. The court concluded early on that the government intrusion into an employee's privacy and associational rights, when not relevant to her on-the-job performance, could not withstand any level of scrutiny. Now, it is certainly important that a police department maintain order within the department as well as the confidence of the public that it serves. However, employment with law enforcement, as with any government employer, does not minimize an employee's right to personal autonomy. Because the state cannot demean an individual's existence by penalizing her private sexual conduct, a government employer must show a significant impact on the employer's workplace to justify an unwanted interference. As the initial Perez opinion suggests, conduct unbecoming an officer is not a legitimate reason to warrant such an intrusion. In closing, I will leave you with a quote from the late Judge Reinhardt. As a society, we must remain solicitous of the constitutional liberties of public employees, as of any citizens, to the greatest degree possible, and should be careful not to allow the state to use its authority as an employer to encroach excessively or unnecessarily upon the areas of private life, such as family relationships, procreation, and sexual conduct, where an individual's dignitary interest in autonomy is at its apex. Thank you.